Welcome to the third episode of UNODC's Global Judicial Integrity Network podcast series. Today we will be looking at the application of the Bangalore principles of judicial conduct to court administration and case management. Our speaker this month is Judge Jerome Abrams of the United States of America.
Greetings, and thanks for joining this podcast. My name is Judge Jerome Abrams. I'm a judge in the state of Minnesota, United States of America. I'm a trial court judge, or some of you might think of me as a first instance judge. I've been doing this work for over 10 years, and I take on all types of cases, whether they be civil or criminal, whether the civil cases are small or large, from thousands to millions of dollars, criminal cases from simple breaches of the peace all the way up to and including murder. I come to this job with a background largely doing civil litigation throughout the United States, actually going to trial in cases where the disputes were largely over money and liability for damages inflicted by one reason or another. I did this for clients large and small for almost 30 years. I also had the opportunity to do some work internationally, participating in arbitration processes in Western Europe. I've been asked by the United Nations Office on Drugs and Crime to comment on matters related to what responsibilities judges have to see to it that their administrative staff and court administrative officials follow ethical rules. And in that regard, I've got a series of questions I'm going to be responding to. And the first one deals with, of course, the Bangalore principles, which command that competence and diligence resulting in efficiency are really at the heart of a judge's responsibility. Should court administrators be held to the same ethical standards as judges? I could give you a long and involved and complicated answer, but the simple one is yes, of course, they should be held to ethical standards. The difference in degree, though, as to whether or not their standards should be the same as for judges is sometimes a matter that's best left to local discretion and discretion of the judicial officers that are involved. And I'll explain some reasons for that. As judges, of course, we have a separate set of unique responsibilities which are placed upon us by the laws or the rules or the systems that gave us our jobs and give us the responsibilities we're asked to perform on a daily basis. In some places, court administrative officials may be elected and subject to a similar set of laws, or may be appointed and subject to a similar set of laws. And in some places, they work solely at the direction and at the pleasure of a court official, such as a judge or a presiding judge or even a judge of a higher level court. The bottom line of all this is, however, is that in the absence of court administrative officials operating on a sensible, ethical plane, the public will lack confidence in everything that the court does, whether it's the actions taken by a judge or the actions taken by court administrative officials. In other words, administrative officers, the support people who give you the cases, who file your decisions, who schedule things, who communicate with the public, must in and of themselves operate at an ethical level that not only can one be proud of as the immediate recipient of their work, but also proud of as their supervisor. There's nothing that is done in a court that doesn't ultimately reflect upon a judicial officer who sits in that court. So the short answer is yes, administrative officers should be held to ethical standards. The same ethical standards that judges have is obviously an ideal standard, but nevertheless, if that isn't practical or feasible, there must be some set of ethical rules to guide them so they avoid any type of impropriety, appearance of impropriety, or any type of conduct that shakes public confidence in the rule of law as administered by you, the judge. So the next question I've been asked in turn is, as a judge yourself, what measures do you take to ensure you are also an effective administrator? As part of a judge's job, things don't happen for us instantly and automatically and as a direct result of our own efforts. In other words, the work comes to us through a process. Our work is in turn referred to another process to be disseminated to the public. To be aware of those processes is an absolute essential facet of the job. In addition, how to do administrative work better, how to do administrative work more efficiently, how to understand technology's role in applying it to help the operations and get the public to understand the workings of the court is an affirmative responsibility of judges. In other words, while judges themselves don't have to be administrators, they must understand administrative processes. They must be able to act in a way to get others to act in order to ensure the orderly operations of their various tribunals. So judges themselves have to be good administrators in terms of managing your own work, managing your day-to-day tasks, and you also have to be very understanding and knowledgeable about the processes that others engage. So the next question I've been asked is, what has been your experience with developing quantitative indicators for successful case management in general, and how do you tackle inefficiency when you find it? As the age-old story goes, garbage in is garbage out. In other words, having technological means to support your operations is as good as those technological means are that are employed. I know, for example, the National Center for State Courts has been using some open source software which assists courts in providing effective case management utilizing generally available case management principles. My view is that all aspects of case management and case control ultimately are the responsibility of assigned judges. Further, a judge's ability to provide indicators for successful case management also depend in some measure on the local legal culture. Now, typically, the standard or measure for whether or not a court is effectively operating and effectively managing cases is this reliance on statistics which deal with things such as time or age pending of cases, that is, time to disposition. How long does it take from the time a case gets filed with the court until it's got a decision associated with it that is considered to be a final decision? So that's considered, just relatively speaking, time to disposition as a statistic. And another statistic that's often kept or used to determine how well a court is doing is looking at something called clearance rates, which is how many cases are coming in on an annual basis as new or initiated, how many cases are leaving on an annual basis. And this can be broken down into even smaller intervals of time, whether it be even daily, weekly, or monthly. Effective case administration and case management doesn't necessarily depend on either one of these two measures as sole criteria for efficiency or efficacy within the courts. In other words, courts doing a bad job quickly is probably worse than doing a good job slowly. There are some inferences, however, that can be derived from these empirical measures of clearance rates and time to dispositions. If they are unusually long, or in the case of clearance rates, unusually not reflecting some reasonable relationship or proportional relationship between the number of cases in and the number of cases out in a given period, obviously there's problems that are present. Now, when one finds these issues going on that seem to need to be addressed, there are several different ways for tackling inefficiency when it's observed. The principal way that I found to tackle inefficiency is to just shed light on the problem. Usually there's a cause or a source, whether it's an administrative cause or a source, or a judicial cause or a source. We have to recognize as judges that ultimately, since we bear responsibility to the public for our role of getting things done efficiently, and this is even borne out by the requirements of the Bangalore principles, and certainly in Bangalore principles, competence in judicial administration. It's in the commentary found expressly at commentary number 196, but certainly part of the competence and diligence requirement of value number 6 of the Bangalore principles. We need to, as judges, specifically under 6.2 of the Bangalore principles, we need to, as judges, invest ourselves in knowing enough about how our court or courts work to know when problems arise, how to effectively deal with them. So going back to my earlier statement, there's usually this notion of cause and effect. And as a court administrator, direction is to be given to them by us and to be taken by them from us as to where to spot inefficiency and where to correct problems. The bigger challenge that we often face in effective administration is when those people who are supposed to bear the responsibility for this, that is judges, are the actual source of the problem. Now, there's a couple of different ways that this has been dealt with, some of which are gentle and some of which are very, very, how shall I say, for lack of better expression, extreme. There are several states in the United States whose state court systems require that in the event that a matter is finally submitted to a judge, in other words, all the oral and courtroom presentations are done, all the written submissions are in, and the judge doesn't decide the matter within 90 days, the authority of the administration is to stop the judge's paycheck. In other words, the judges our wages are withheld if they're more than 90 days overdue with a written decision or an order or some type of action that they're required to take on a matter that's finally submitted to them. This is certainly the case in the state of California, which is the largest and most active jurisdiction in the United States. It was a strict rule in my state. It was slightly relaxed, but ultimately, for example, if I'm more than 90 days overdue on something and somebody complains, they can get my paycheck stopped. Now, mind you, as a litigant, it's probably not the smartest move in the world to challenge a judge from whom you're expecting some type of favorable decision to tell them that until they make it, they're not going to get paid. But in any event, this does, in the most extreme sense, force judges who are non-compliant with timeliness rules to actually clear their desk, so to speak, and get their work done. When problems arise in the administrative realm, again, it's the responsibility both through the commentary to the Bangalore Principles, as well as expressly in the Bangalore Principles in Principles 6.2, 6.3, and especially Bangalore Principle 6.5, that judges need to perform all judicial duties, including the delivery of reserved decisions, efficiently, fairly, and with reasonable promptness. Now, I'm moving on to another question that was raised to me. Should courses in topics such as finance or electronic case management or case management in general be mandatory as a part of a judge's professional development? In a word, yes. And then the suggestion is also other topics. You know, historically, the job of a judge used to be very easy to define. We were to take matters that are submitted to us through ordinary processes of law, consider them and decide them, and record in some effective way for parties to understand what it is our decision is, and then folks take it from there, whether it be the public or administrators. Today, there is such an increase in the amount of available information, things like news cycles, which operate, as we all know, on a 24-hour basis, matters related to just the general proliferation of civil and criminal litigation. Importantly, the general proliferation of laws regulating conduct, both civilly and criminally, of people in our society. There has been this explosion in terms of technology and its adaptation for use in courts, not even to mention the pressures placed upon all of us by social networking activities that are undertaken by forces sometimes we know about, and many times by anonymous forces we don't know about, that ultimately judges need to be not only aware of the traditional things that make judges' jobs work, the core values, that is, knowing what your responsibility is, knowing how your court operates, knowing where your court effectively interacts with the public, that is in terms of access to justice, in terms of access in general, knowing where kind of both the strengths as well as the weaknesses lie. There are so many other topics that judges need to know about, including matters related to finance, that is the effective operating of court organizations, knowing what they cost, on what they spend money, where the money comes from, and how to efficiently and effectively be good stewards of that money. That in itself is a discipline that historically would be outside the purview of a judge's personal knowledge, but today is extremely necessary. In addition, judges should have a good knowledge of basic products which are necessary for a judge to do their job. Through the course of my own career, I've gone from the point where every file existed on paper, and including some court reporters, verbatim court reporters, still use pen and ink, to the point now where everything is electronic and our environment is as much as possible paperless. To know and understand not only how this stuff is generated, that is, how records are generated, kept, maintained, disseminated, as well as for one's own use, that how to operate word processing programs, spreadsheet programs, and case management programs. These are all essential components of a judge's job today. Now, I have been involved in the transfer of our court paper file system to an electronic filing system. And make no mistake, courts gravitate or courts migrate from an environment from paper to electronic images. It doesn't necessarily involve the development of an accessible database of everything on those images as an ultimate goal. In other words, there is much value to be derived from the intermediate process of going just from paper to electronic files for a variety of different reasons, and largely for promoting efficiency as a principal reason. A secondary reason, of course, is also providing access to justice, that is, making the portals or the entry points into the judicial system, into the courts, easier for people. And as a sort of tertiary or other third main feature behind the switch to an electronic file system is to provide transparency. And it does, in many respects, promote the public's confidence in the court systems when they know that they too can see exactly what's there at a time or near a time when it's actually being considered by the court. Now, one of the negative consequences is that sometimes this involves confidential information. And in our own transition to an electronic system, we have had some difficulties in finding effective means to filter out that which could be used in a negative way. That is, information that's necessary to be filed with the court that can be used in a negative way by those people or those organizations that have, of course, evil in their hearts and are seeking to exploit any opportunity for their own gain. But what we've discovered is that with a certain amount of training and with a certain amount of diligence and with a certain amount of administrative efforts, that we can isolate that type of information, that is personal information about an individual, about, for example, their accounts, identifying numbers, passport numbers, and the like. We can find a way to sequester these from public access so it's not a problem. Additionally, there is a reliable means utilizing OCR, or optical character recognition software, that's gotten so much better through the years that if given the parameters to search all records, much of this OCR software, and frankly some of it's very, very available, very much off the shelf or available online, so to speak, in terms of it's effective, it's inexpensive, and it just takes a small amount of time to program it effectively. But what I'm getting to ultimately is that while there is a risk associated with obtaining confidential information, it doesn't take an extreme exercise of diligence to make sure that this information gets or stays in the right hands. It doesn't take a lot of effort to make sure it stays out of the wrong hands. Now, for those jurisdictions that don't have ready access to technology, The best thing one can do is start to utilize that which is easily or commonly available at little or no cost. I even began my career before becoming a judge by creating databases and using very, very basic software. For example, in my office we use Microsoft products, and one simple database tool was Microsoft Access. In other words, just having a centralized organizational system on software that is widely available and shared. I might ask a hypothetical question at this point: who in the world does not have access to basic Microsoft software? And I think the answer, of course, is that everyone has that access. But my point is maybe a simpler one. Just implementing on a regular basis. I mean, you don't have to get yourself to the point of being some unit of a giant blockchain system sharing files, but just having files in a format. Going back to the earlier days. When I say the early days, I'm talking about when data existed on magnetic disks. They were round, sometimes floppy, and even as large as a pizza. And you used to share these things back and forth in order that you could actually have an exchange of information. It's obviously not that hard to do today, but even people with very, very minimal access. Frankly, the last statistic I heard is that more people in the world own smartphones than toothbrushes. This is to support my point that rudimentary access to technology is available at every level, and people should seek to exploit common technology for furtherance of court administrative requirements. Now, I was also asked, have you collaborated with other government branches to improve court management? And again, simple answer to that is no. There are many reasons, but frankly, there have been concerns expressed in the past because courts need to be isolated in the sense that when people come to them for purposes of a decision, the decision should be based, because of concerns of fairness, it should be based upon the information which is actually presented by both sides through an orderly, rule-bound process. Sometimes the sharing of information with other agencies may cause, for example, in a criminal case, information to be submitted to the court, whether it's correct or incorrect information, without knowledge or notice to the defendant in a criminal case or the defendant's counsel. So for a number of different reasons, we have not automatically shared information with other governmental agencies, nor have other governmental agencies shared information with us. Our view, and this may only be my view, is that courts' information systems are to help courts themselves operate, to help courts interact with the public, providing fairness and access, to help courts provide transparency so there's public faith and confidence in the processes. In other words, we're not necessarily designed to help other agencies, nor do we expect help from other agencies be provided to us. That doesn't mean that our records shouldn't be made available to other agencies. I'm of the view that court records should be made available to everybody who wants to look at them. And frankly, they should be made available either as inexpensively as possible, and the presumption should be is that anything a court does should be free and available to the public. Now, I was also asked about our work with alternative dispute resolution and whether I view arbitration outside of a court as complementary alternative to the judicial system, or I'm asked if do you think that with increasing efficiency, arbitration will or even should become more obsolete. Well, I can tell you, as a matter of fact, in my part of the world, arbitration of disputes has the official approval of the United States Supreme Court. That is, in the event there is a contract between two parties which includes arbitration as a means of resolving disputes in lieu of going to court, that provision is to be given effect and the arbitration provision is to be honored. So my point is that because it is the law of the land, and that's a decision of the United States Supreme Court, obviously that law is followed. However, arbitration is not a substitute or an outlet as a part of case management. If a case is properly before the court It can and must be managed by the court. My simple mantra is that every case, once it hits the courthouse, once it's filed, whether it's civil or criminal, there should be a plan for its disposition. Most of these plans rely on compliance with rules established ultimately for cases being heard and for final decisions to be rendered. There are some types of cases, both complicated criminal cases as well as complicated civil cases, that can't exclusively be rules driven. And these are the types of cases that require judges as managers to become involved with the parties or to be knowledgeable about the case itself in order to establish and order intermediate steps so that the matter can be fairly and efficiently resolved. Now, as a final matter, I've been asked, how big of a role does public perception of justice play in court management? I used to think before becoming a judge that perception was important but not determinative of anyone's faith in an institution, that one always gets a chance to challenge perceptions and change them. But public institutions are different. Courts, in fact, are driven by perception. Perception is, more often than not, unfortunately, the equivalent of reality. So if people think courts operate fairly and efficiently, even if they're actually operating unfairly and inefficiently, it doesn't seem to matter. And again, the notion is public perceptions about court operations are crucial. Now, I have found much success in public's perceptions of things like expedited court procedures for civil cases. We've had great success, as have many courts throughout the United States, and programs developed by the National Center for State Court Civil Justice Initiative, which has actually increased or enhanced the public's perceptions of our operations. If courts operate well, people invariably also think that they're operating fairly. That is, everybody's concerns are being addressed, and even decisions that people may not like at the micro level, at the macro level, people will understand why the decisions were made and why they should be followed and enforced. And I'm kind of coming to a long conclusion here after almost 30 minutes of this discussion, is that the ultimate reason why people have a high opinion of courts, it's courts they can relate to because of transparency. That is, no courts are ever viewed, and there's a double negative here, but I'm going on this. You can't develop a favorable view of your court if you're in any way hiding its operations. That's not to say that the decisions reached by judges shouldn't be decisions reached based upon the record. Judicial independence, which is a hallmark of judicial integrity. But folks have to know when cases come in, what happens with their cases, when cases get decided, what the decisions are, and they should be able to do so in some reasonable amount of time, with no expense or little expense, with some reasonable amount of efficiency. And in this day and age, given the type of volume we deal with, there is no substitute for incorporating technology to assist in this process. Now, there's one small area in which I'm going to digress in just the last minute of this long conversation, is sometimes when people are unhappy with courts, they make unfounded or baseless assertions or allegations that need to be vetted or investigated before they become public. And this is an essential matter. In other words, courts can be hijacked, and it's kind of a strong term, or judges' integrities can be eclipsed or taken over by people who make unfounded allegations that are accepted superficially as being true before some amount of investigation takes place. About the only area where there's room for some amount of delayed or deferred disclosure of what's taking place within the courts is when judicial officers or courts are attacked by reason of some type of conduct they're alleged to have committed before there's some preliminary determination made as to whether there's some substance to the allegations that are being made. But apart from that, you can't beat sunshine for providing confidence to institutions. Again, My thanks to the UN ODC for allowing me this time. This is Judge Jerome Abrams. Thanks again, and I hope things work smoothly in your courts.
Thank you, Judge Abrams, for sharing your insights on upholding competence and diligence in court administration. Stay tuned for our upcoming podcasts in this series, and be sure to subscribe on iTunes.